Let me do a couple, shit. Do a couple things. Make sure we're ready to roll. Because Wirecast isn't working for me right now. And remember, on the way in, hit that like button. So let's see. Come on. All right. All right, here we go. Welcome back, everybody. I appreciate you guys. Now, again, we're going to talk about something that came up and it came up in conversation, I want to say about 2 or 3 days ago. And again, because I have non-regular conversations, apparently. Now, in the midst of doing that, let's get right. In the midst of doing that, today we're going to dive into the bedrock principles of criminal law. Because a lot of times our misconceptions is what kind of drives us into either not asking the question or not getting a full understanding of what the question that we're attempting to ask is. We're going to talk about the bedrock of criminal law, which is 2 principles. Really, they shape every courtroom battle in America. They shape every courtroom that is set forth in a position for you to actually have a direction. First, who controls the strategy in a criminal case? The lawyer or the defendant? And the reason why this question actually comes up or is arising or whatever, however you want to put it together, is because there's a misnomer of understanding and a relegating of you don't know how powerful you really are. I did the video, simply speaking, about we're more powerful than we actually know because it's not our darkness that we fear, it's our light. And a lot of times because we're the defendant, we feel that the attorney that's working for us, they're the, how do you put that? They're the authoritarian, when in fact, you are the employer. You make the decision. And then second, why every person accused of a crime walks into a courtroom cloaked in innocence until, and only until, the government proves guilt beyond a reasonable doubt. Why is that ever not an option? Because it's not even an option when you go to plea. You're either guilty or you're not guilty. Innocence isn't even an option. But the presumption must always be there. Now, these aren't hard abstract theories. These are congressional guarantees. They come straight from the 6th Amendment, right to counsel. The 5th and 14th Amendments guarantee of due process, and they've been hammered out in real cases where real lives were on the line in the highest court of the land, which makes them the supreme law of the land. So over the next few minutes, I'm going to walk you through why the defendant, not the lawyer, ultimately has the final say in strategy. They can't just not do what you're asking them to do. And I'll bring you to a landmark case of Farrett v. California and my favorite, McCoy v. Louisiana, because that is my go-to, because there's no ambiguity in understanding McCoy v. Louisiana that draw the boundaries between attorney advice and client autonomy. Then we're going to pivot to the presumption of innocence, tracing it from the earliest recognition in Copeland v. United States to modern refinements in Winship and Taylor v. Kentucky. Along the way, I'll show you these doctrines aren't just words on paper. They're weapons. This is how we weaponize our defense. Shields, tactics, tools that criminal defense are built on and used every single day. By the end of this episode, you'll understand why the principles aren't technicalities. They're the options of, they're the oxygen of freedom. Without them, the criminal justice system suffocates until under government power. With them, the individual stands tall, protected by the Constitution itself. So let's go. Now, got to get my water first before we go, because I get a little excited in that first couple minutes. All right, actually, thought I had water. I actually ended up pouring me some tea. Anyway, who controls the defensive strategy? Well, let's see who the Supreme Court told me, the supreme law of the land. Now, the Sixth Amendment's right to a counsel as a balance. You choose who you want to speak for you. Whether you're going to have an attorney that's assigned and then you're just accepting it, or you're going to go into how you're instructing this mouthpiece to work on your behalf as an employer. Remember, think of a defense attorney as this. If they're assigned to you, they are assigned to you because they are your employee. Why are they your employee? Because they were assigned to you by another person who was employed by you. It's almost like a manager having a new hire and you're training the new hire. That's what a public defender is. Now, let's say you go out and secure your own attorney or representation. Guess what they are now? They are your employer. Your employee. How are they your employee? Because you are cutting their check. Literally. This is why you are the one in charge of your defense. Let's say they choose not to do that. There are consequences for that. Line by line, step by step, precept upon precept. And always get into it. Now, Farrah v. California gives you the right for self-representation because, again, your choice of counsel can be whoever it is that you like, even if it is yourself. Discuss McCoy v. Louisiana. A lawyer cannot concede guilt against the client's wishes. The client is the ultimate determiner of their fate. That will make the defendant the most powerful person in the courtroom because they are the one who the judge works for, who the prosecutor works for because they are the people. And then the person that you directly employ, the defense attorney, works for the defendant. See how all that works together? Everybody there is working for you, and they must work towards your benefit. So if they are attempting to make decisions for you without your consent, there are then consequences for that because they can't speak unless you are offering it as an option. Now, the tactical decision that most lawyers are going to throw out versus the fundamental. Here's the thing. I always give this because I advise people constantly for the most part. But I let them understand this is expectation management. I'll give you what you need to win. If you choose to alter it, it's on you. If you don't follow instruction, it's on you. Why? Because it's you who have to pay the price for any inconsistencies and not being able to execute in a manner in which you're actually asking me to help you with. That is the exact same thing that is supposed to be done by your counsel and your counsel of choice. Accepted choice. Let's use that. Because everyone, even if you're assigned a public defender, you can then make sure they're doing what you're instructing them to do. And if not, there's a penalty to pay. Why? Because of McCoy v. Louisiana. They can't just unilaterally do anything without your consent. Now, whether you plead guilty, testify, accept the plea, or maintain innocence, all of these are your decisions. Your representation cannot do that for you unless you give them written authorization to do so. I'm going to repeat that. Pleading guilty, testifying, accepting a plea, or maintaining innocence. Those are your decisions to make and yours alone. Unless you offer your representation written authorization to do so. Now, let's say you are the driver of your case and you have an attorney. That lawyer is the navigator, or that consultant, which I would be the navigator. I can tell you what's ahead. It's up to you to determine how you're going to proceed going ahead, because those are your choices. Because I may know the road, your attorney may know the road, but the driver decides where to go, and that's you. Always understand that. Now, I'm going to give you a few other ones that offers you defendant autonomy. Jones v. Barnes, counsel can choose which issues to raise on appeal, but can't override the client on core trial strategy. Again, looking at certain aspects, understanding what you can and can't say and do is the job of counsel. Notice I didn't say attorney. It's counsel, because even your attorney is your chosen counsel. Someone that's guiding you is your chosen counsel. You yourself is your chosen counsel. But your decision and core trial strategy is yours and yours alone. Brookhart v. Janus. Lawyer cannot waive the client's right to a trial without the client's consent. Again, you have the power. McCoy v. Louisiana. If you are insistent on innocence, no lawyer can concede guilt in hoping for leniency. That is that actually violates your autonomy, because it is a direct violation of your civil rights and due process rights, because it's your decision, not your counsel's. Now, there's a tie to how would I say? Let's say your dignity for the most part. The court recognized that the human right to tell one's own story, even if it's strategically foolish, is the right of the defendant. Because again, just to give you an example, yesterday I spoke about myself and going to trial. The one thing I did not want to do and was not going to do was testify. Why? Because I have a horrible history. It is littered with arrests. It's littered with a couple of violent arrests. No convictions, but it's just a bunch of arrests for not good things. You know, like being arrested for good, but it's for not. There are some violent arrests that's in there, and not going up there was a strategic choice. Now, had just because again, I advised my brother not to do it. He also chose not to, because I gave him a reason why not to. But at the same time, had he chose to take the stand, there is nothing we could have done to stop it, because it is his decision and his alone. We don't have to like it, but we do have to live with it because that's the law. Now, the reason this matters for defendants and the attorneys that's working with you or for you. Failure to follow a client strategy can be grounds for reversal, mistrial, and sanctions. Consequences. Because no one wants a case reversed on their watch. And even with sanctions, it can also go to the defense attorney, the one that's defending you. Because at the end of the day, not following instructions is detrimental. It is not just a free fall where you can do whatever it is you like, or they can do whatever it is they like, and there not be consequences from it. Now, the presumption of innocence. The issue is it's supposed to be the presumption of innocence until proven guilty. The problem is you're guilty until proven innocent, and then that stigma still stays with you. Why? Because this is a business. This has nothing to do with law, which is why the first thing they do is bring up something bad you did prior to being arrested. Oh, in kindergarten, he stole crayons. Oh, he didn't participate well at nap time and he hit Sally. You're like, oh my God, he was a violent baby. Then they take your mugshot. They take your mugshots and post it online. And they put a story under it where they know nothing about the incident. But again, this is depicted as you. And going through this takes away, or it's called performing in front of the jury, poisoning the jury pool, just in case you're stupid enough to go to trial, which gives you the greatest opportunity to be found not guilty. Yeah, I said that because I want you to understand why the ploy is there and understand why they are acting in the manner they are, because this is about psychological warfare. Because they can convince you not to do something and put them in the worst position for them, they're going to do it, which is why they use intimidation tactics and do not follow law. So the historical roots of the presumption of innocence is Coven v. United States, and it's from 1895. And it articulated the actual presumption. And why? Because it's based in empirical, inalienable rights, not from man, but from God, because your birth gave you innocence. Don't worry about it. I'm not going to go too deep in that because I know that doesn't make people comfortable. And right now, understanding that aspect of it is only a microcosm of what it is that's needed in this. So that's why I'm just kind of go over it, because it goes deeper. Now, in Winship, which is a 1970 excerpt, the government must prove beyond reasonable doubt for each and every fact, which is why I say challenge everything. Say that one more time. Challenge everything, because the government must prove beyond a reasonable doubt every fact, which is why they have procedures in place for them to preserve and find those facts. That's why you challenge it, because they don't ever follow it. I could say this until I'm blue in the face, but if they actually followed law, I would not be needed. I would not be necessary. And people that are innocent and intelligent would not be going into the issues and having the issues in which they're having, because they believe this works as it's written. And most people have no idea how to enforce it. Now, Taylor v. Kentucky. The jury must be instructed on presumption of innocence to ensure fairness. That jury instruction generally is not read unless the defense orders it read to the jury. Why is that? Because if it's not read to the jury, it actually gives the prosecution 1 or 2 more points to win, even though they're still losing 76% of the time. They want that 1 or 2 more points by not adding that jury instruction. Because presumption works in practice, the jury instructions, voir dire, and opening statements. The problem is they're not put into these places on purpose because this is not about law. Say that one more time because a lot of people miss it because they think just because they see it on TV, that's how it works. And it's not. Even on TV, it's not working like it's supposed to. It actually does not work like it does in real life, or for the young folks, IRL. But understand there is a presumption in working it into the jury instructions. Voir dire and opening statements are the essence of making sure, let's call it human nature, kicks in and stays in. Now, the connection to due process is going to be without the presumption, the burden of proof flips. And it becomes an inherent risk to your actual innocence. So if you're not asserting the presumption of innocence, it becomes a burden to your actual innocence. And again, making it about your innocence and not attacking their alleged facts becomes a dangerous game to play as well. Because understanding innocence is a vacuum for the most part, because it generally does not have anything to do with law. Because law doesn't care about innocence. But understanding where it lies at and how to weaponize innocence is one of the great moves in chess. It's not even an opening move. It's a secondary move that you would do. But it's one of those that play a key role when you see down the road that pawn is going to mean something. This is how you set that up. Now, hypothetical. What happens in a system where presumption doesn't exist? It shows a danger of conviction by rumor, prejudice, or suspicion, which is why they dirty up your name prior to you ever making a decision or actually having a case that can be or will be tried. Now, one of the easies, because I see a couple of my brothers in here. Practical implications and defense tactics. Trial strategies. The constant reminder of the presumption of innocence. Always work in the idea of 3. You want to make sure the jury hears it because there are certain places that we are programmed to understand where that comes from and make them pay attention to it. Again, a subtle reminder of how it's done. And one of the ways we did it, like I said, my brother did it in reverse, but saying it on the stand, I added it to my closing statements. And believe it or not, I got one of the police officers to say it. But again, we didn't use innocence. We actually programmed not guilty of a crime. Because again, not guilty, not guilty, not guilty. Why 3? Because 3 is the number for completion. This is also the 3 is the programming in which we're receiving. But we have to do things in a certain process and pattern to which the brain can actually register it. So understand that. Because even in motion practices, you're attacking indictments, you're suppressing evidence, you're forcing to state to prove each and every step. Because even the indictment is something you can challenge. The evidence that they gather is something that you can challenge. The police report is something you can challenge. Body cam footage is something you can challenge. The police character is something you can challenge. But again, it's also setting it up properly and not just randomly throwing stuff out there and hoping it sticks. That's why you go out and you get guidance, whether it's an attorney, whether it's a consultant, but it's someone who does this for a living, not a novice. You want someone that's been there in the trenches. You don't want someone to stand on the sideline and guessing. Because we actually had a conversation once before in ICE. And the idea is, would you want a plumber doing brain surgery on you? He works with tools every day. He's watched it on TV. He actually has to be gentle in certain moments, just like a brain surgeon. Would you want a plumber operating on your brain? No, you want someone who actually does this to do it. Hence, why would you listen to something? Because I've even given you the story of my uncle. We're at Thanksgiving dinner. And actually, it wasn't a Thanksgiving dinner. It was during the summer. I know it was a dinner, and all of us was together. And my nephew comes over to me, and he goes, "Hey, me and my wife are getting ready to start this business. Can you help me and give me some direction?" So before we could even start talking, my uncle jumps in and says, "Hey man, if I had that business like you, I'd do this and do that." So he talks for 10 minutes. He said, "Yep, that's what I do, make me a quick million." So me being the asshole I am, I looked at him, I said, "Uncle, is that how you made your million?" He said, "Well, no, I've been working at the factory." I said, "Exactly. Why would you offer him advice on something you've never done?" It, to me, is asinine. He's asking me because I've owned several successful businesses. He's not even talking to you because you've always been an employee, not employer. So he's trying to get somewhere he has never been. You can't take him there. You can't even do nothing but get in the car with him and ride. But understanding this is the same way, because just like I just spoke about trust a few minutes ago, or about an hour ago, you want someone who knows how to put one together, who has one that's put together, who does this. Because I tell people, I don't play law. This is my life. This is a lifestyle. Understand the context of what it is that I'm doing, and I do it at a high level. Not just because it's something to be done, but it's something that I do with a passion. But again, staying focused is making sure you're getting somebody or getting guidance from someone who actually cares about what you're trying to do and actually does this at a high level. Generally, that's going to either cost you a lot of money or it's going to cost you a lot of time. One of the two you're going to pay for. So understanding the presumption also needs to be done in a storytelling manner. You're welcome. Because you're going to weave the presumption into cross-examination, which I told you about the police officer. You're going to do it during your opening statements. I did not do it in my opening statement. My brother did it on the stand. And then you're going to do it in closings. I did it in my closing. Because again, in increments of 3, cross-examination, openings and closing. You don't have to use the exact setup, but make sure it's programmed 3 different times. Now, using it as a shield, you don't have to prove innocence. The government does. Here's what I mean by that. You don't have to prove that you're innocent. The government has to prove beyond a shadow of a doubt that you did it. You just have to make sure it's not easy. Because actual innocence and a Implied innocence are separate issues, and neither one of them belong in law. I want you to understand that, because even going through this, because just like Survey just pulled up, I've been in the game for a while. I've been active at this. I've been programmed to do this since I was 9, 10 years old from my father, who was a Mason. I've been active at this, like legitimately active, since 2008. It's cost me a family, it's cost me my wife, it's cost me my kids. But at the same time, it's come full circle because it's offered me an opportunity to see the world differently, because I can see it as it is, so I can also see all the moves that are being made. And they're the nature of the beast never changes, just the players. That's it. And even to the point now, I've how can I put that? Even now, I decide if I'm going to be going, matter of fact, let's put it, I layer it out depending on how aggressive I choose to be. Because even in these contexts, it's, do I want to play with my food, or do I just want to get this over with? Because a lot of times there are things that are, just like I spoke about, bad facts. If I have bad facts, there are certain things that I don't want seen. So there are certain moves I'm not going to make. And I understand that. Because even, hold on. I got a comment I want to read. Neither defendant nor plaintiff controls it. The purpose of cases is justice. The party with the best case wins. That is an absolute lie. The one who doesn't control it is the one who believes that. I want you to understand that. And I'm standing on what I say because, one, you haven't been here. Two, in order to understand the context, you are the one that controls everything. Why? Because the law say you control it. Your choice to control it is what lies in there. The plaintiff controls jurisdiction, where the case will be heard at. See, this is where I always tell you, the smart people get caught up because they think they don't have control. And I've actually given you several cases which explain your control, but this intelligence will say, no, those cases that have been around since 1895 are wrong. The Supreme Court's decision is wrong. And I get where it comes from, because it comes from a place of fear. And as long as you have that, it is difficult for you to see anything else and actually be successful. Because false expectations appearing real are your perception, because perception is king. And just like I said, I lost my family because of this, because to beat a monster, you have to become one. The problem was, when I was fighting this monster, I became a monster. I became a bad father. I became a horrible father. I became a horrible husband. I became a horrible friend. Because again, everything that I saw was a nail, because I'm a hammer, and it just hit it, and I was angry, because that's what the beast is. It's just anger. Now that I'm able to step out and look back and control, because I even put up a post, and me and my ex, we talked about that yesterday. The fact that she asked me, how are you able to kind of control yourself now? And I said, I made friends with all my demons. We have an agreement. They only show up when I need them. Once I took over control, added discipline in my life, and let go of all fear, I became the monster when I want to be it. Because my whole thing is, you don't bother me, I'm not going to bother you. And then I'm going to decide, if you bother me, how long I'm going to play with you. Because sometimes I do like to play with my food. It takes me, I fix me a plate, it might take me an hour and a half to eat it. Sometimes I don't even finish it the first round. I might go back a couple hours later and eat it. Sometimes I'll sit down here and make sure I devour every bite of it. Because again, it's my discretion, my choice. I control everything and everybody in the courtroom. I can tie the judge up. I can tie the defense attorney up. I can tie the prosecutor up. And if they choose not to act accordingly, I'm going to tap those pockets. I don't operate from fear anytime. And you shouldn't either, which is why I give you cases you can look up. I'm not just talking. I'm not just throwing stuff out here and hoping it sticks and nobody pays attention. I've actually repeated the cases, and the ones I couldn't say properly, I spell, because I want you to fact check me. I don't want you to just, he said that. No, go look it up. Hell, matter of fact, I'm going to give them to you one more time. Taylor v. Kentucky, the jury must be instructed on presumption of innocence and to ensure fairness. Winship, WINSHIP, 1970. Government must prove guilt beyond a reasonable doubt for every fact. Coffin, 1895. Coffin v. U.S. Must be understood the presumption is real. The presumption of innocence must be stayed in. Hold on, I know there's one more. Jones v. Barnes, 1983. Counsel can choose which issue to raise at appeal, but cannot override the client on core trial strategy. Who is that? The defendant. The defendant is the one who has ultimate autonomy. Brookhart v. Janis, 1966. A lawyer cannot waive the client's right to a trial without the client's consent. Whose consent does it need? The defendant's. The defendant controls every aspect of it. McCoy v. Louisiana. Defendants insisting on innocence. The lawyer conceded guilt, hoping for leniency. SCOTUS said that violated the defendant's rights. Why? Because the defendant controls it. So whenever I said that was a lie because that was an operation from fear. We don't do fear over here. Fear does not live here. And I hate to say this too, defending yourself is not a right. It's not for the weak of heart. It's not for the simple mind. It is one that must be able to stand strong, which is why, again, I didn't speak about the Minnesota riots, because the national average is 5% of fight backs. The amount of people that was arrested versus the amount of people that fought back during those Minnesota riots that were arrested was below the national average of fightbacks. The ones that fought back, 75% of them won. This is what I'm talking about. Less than the national average. The national average is 5%. Everybody's strong with no resistance. Everybody's brave when there's nothing to fear. When nobody's coming at you, everybody's brave. The second someone talks crazy to you, because again, I watched it with these bastards that testified against me, and I mean it the way I just said it. I'm thinking, this is my friend, this is my dog. No, she just got out of jail. Why? Because she took a deal for a crime she didn't commit, and she was a witness. They arrested her on a material witness warrant. And I thought this young lady was my friend. My brother like, no, she's not on your team, bro. Because she was acting out of fear. Had another dude took a deal right before trial, literally the day before trial. Why? Because he was acting out of fear. He got pissed at me because we won the case. And he had to go to prison. Why? Because he was scared to stand up for the stuff he was talking about. He was wondering, man, the feds kicked the door. I'm going to do it because we saw it coming. Here's the crazy, my wife saw it first. She was like, okay, when they come and arrest you, because they coming, what do you want me to do? How do we set up this money? Because they're not going to let you post bail, which they didn't. And like I said, she saw it first. And here's the even crazier part. She stood by me while I was locked up. No communication. I think we had 2 phone calls, and that was actually one to actually name our son. But she, even the day before trial, it was, just to give you something, then I'm gonna finish this off. The day before trial, I was losing it. I'm not gonna play. Oh, I was tough. No. You see 2,000 years, 108 counts, and it's 20 years per count. Yeah. I don't even know if I told her this, but when she see this video, because she watches all my shit, she'll see it was her who first instilled the confidence in me. The absolute beast was unleashed because of her. I was nervous. I was shaking. She grabs me and she hugs me. She gives me a kiss and she said, "I'll see you Friday." She said, because this case ain't gonna last more than a couple days. It ended up lasting until Thursday, 1:04 p.m. Eastern Standard Time, October 25th, 2012. Why would I just give you a date with a time? Because what I'm talking about, these are the things, I'm not just running my mouth, because at the end of the day, this is what this is about. We're about learning, we're about going to the next level, and we're about releasing fear, because this is not how we operate. So whenever she told me, "I'll see you Friday," that released the fear and unleashed the monster that was in me. Because my point was, now I gotta go home. Because she's waiting for me. Because if she can wait while I was locked up, she damn sure can wait 4 days. And Friday morning, I walked through the door. And she was the first, well, actually, she was the second person I saw because my son was there. But anyway, now let me finish that because I just happened to see that. And I'm going to finish this off before I hit that. Don't rely on gimmicks. Go use legislature and constitution and have a stronger case. That's how it's done. I would love to see that person, Henlo. I would love to see you in action. I would love to see some of the stuff that you wrote, because the ability to tell a story is not a gimmick. It's an art form. This has nothing to do with law. If you're going straight law, you're straight lost. Now, not bashing you at all, because I guarantee you're an intelligent person, but you're one of those people that'll get caught up and wonder why, because you're not understanding, again, having all the pieces, but don't have any real clue of how they work or how to use them to your best advantage. And this is what I do when I'm doing these kind of talks. Now, let me go ahead, because explaining that even though you control major strategy, if you have an attorney, a lawyer, or guidance, or a counselor, I shouldn't even use guidance, someone guiding you, use them as leverage during the process, because it's about gaining the most information possible to make an informed decision. Why? Because it's your decision and your decision alone, based on all the Supreme Court cases I just read. So as we wrap up, let's take a step back and see the forest, not just the trees. The criminal trial is not a performance where the lawyer takes center stage. This is your performance. It's your fight for freedom. The Supreme Court in McCoy v. Louisiana reminded us that no matter how skilled the lawyer may be, the defendant's voice cannot be silenced. So even if you're representing yourself, you are the lawyer and you are the defendant that's making the decision. If you have a lawyer, you are the one that's making the decision. If you have counsel, you are the one making the decision, because it's your life and it's your show. Now, Autonomy, dignity, and choice are not luxuries in a free society. They are constitutional mandates. I'm going to say that one more time because most people not going to catch that. I'm going to talk to the cheap seats for a second. Autonomy, dignity, and choice are not luxuries in a free society. They are constitutional mandates. And hand in hand with autonomy comes presumption of innocence, the shield every defendant carries in the court. As the court says in Winship, the government must prove every element beyond a reasonable doubt, which is why you challenge everything. You don't leave one stone unturned. And if you're not part of a vigorous defense, you make sure it is known. Because, again, the easy is not filing a detailed discovery. Or the worst part of that is not knowing what a detailed discovery looks like. Having one that's vague, that can be ignored. Understanding the actual verbiage, the language that's being spoken in court. These are the things in which you need, even with guidance. You need to understand how to move from space to space and how each piece works in advantage to protecting you, the king. That's what the whole rule is, because even in chess, the number one rule is survival of the king, and you are the king in this game. You must position yourself and even those that are your resources in positions to protect you at the highest levels. And understand it's not an option and it's no one else's decision other than yours. And even in this, Taylor v. Kentucky affirmed a jury must be told plainly, this man or woman before you is innocent until proven guilty. This is one of the phrases that is left out of most jury instructions, and as a defendant, you must make sure it is said. Without that, the government could jail people on whispers and suspicion alone. Without it, we force the state to meet the highest burden of law, making sure they are saying this and that 76% actually goes to 80, goes to 90, because they are not doing the job properly. And because they aren't, we must make sure we're not giving them freebies just because we are afraid and think they have power when they are actually employees. So here's your takeaway. No lawyer even though they may have the skill, does not steer the ship. You as the defendant do. No matter how serious the charge, every defendant is closed and innocent until the government strips it away, and with proof, they prove without or beyond a reasonable doubt. These are not loopholes. These are not technicalities. These are not gimmicks. These are the pillars of liberty. Without them, the state is unchecked. With them, individuals stand protected. That's why we fight. And that's why defense exists, to remind the government that freedom is not theirs to give or take. It belongs to the people. So until next time, I'm Supreme Decisions. This is my 2 cents. Spend it how you like. And if you need to get in contact with me, my email is in the description, as well as donation links. And if you like to make sure we keep going and growing, use them. And lastly, if you need a consultation, that's also in the description. And don't forget about Super Chat and hit them likes on the way in next time. And your boy is out.